Okay, this week we are continuing our look at the courts, and we're going to look at court roles and the process. So let's start with court roles. First one is the prosecutor. Prosecutors are the lawyers that represent the state in trials. They are very powerful. They decide whether to press charges, what charges to press, if there is enough evidence, and whether to prosecute the case, and whether to plea bargain. They don't have to charge offenders with the same charges they are arrested for. And they don't have to charge offenders with all of the charges for which there is evidence. It is their choice. You will often hear them called district attorneys, prosecuting attorneys, county attorneys, the state's attorney, or the solicitor. Just depends on which state. Each state might call them something different. They are not supposed to be influenced by personal ideals or politics, but it happens. They are usually elected by the public. A few states appoint them. And often they use the power of prosecutor to move up the ranks to higher positions like mayor, judges, governors, and president. The head prosecutor serves for an average of 7 years. There are also assistant district attorneys or deputy district attorneys who are hired by the prosecutor, usually right out of law school. They do most of the day-to-day work in developing and trying the cases. It is usually a temporary job where they can get experience before moving on. The decision whether to charge someone and prosecute them is called prosecutorial discretion. Ideally, they are supposed to prosecute offenders if 1. They find a crime has been committed, 2. The offender is identified, and 3. There is enough evidence to support a guilty verdict. So why might they not choose to prosecute someone? Well, there's many reasons. First of all, there's a lot of limited time and resources among attorneys. They are very pressed, so they might not choose to charge someone in a case where no harm was really done, just because they have such limited time and resources. The punishment they would receive in today's harsh laws would not fit the crime. Meaning sometimes they tend to not charge someone with the crime, or they charge them with a lesser crime in order to get around some of our mandatory sentencing laws that we have in place today. 3. The motive of the offender did not fit the crime. 4. The law has always been violated without any public uproar. So usually these laws are still on the books, but no one really goes by them anymore. They're outdated. So they're not enforced. Another reason, the victim may refuse to testify. 6. Concerns of the health and well-being of the victim or the offender. You see this a lot in offenders with mental illness or in child abuse cases. 7. The offender cooperates in catching other offenders. So this is basically the only way of getting around our mandatory drug sentencing laws. You basically have to become a snitch on the higher up drug dealers, but in return, you either are not charged or you get a much lesser sentence. And then the offender is wanted for a more serious crime in another area. And lastly, if the offender is on parole, it's sometimes easier to revoke his parole than try a brand new case. So there's many reasons there why prosecutors might not charge someone, or they might decide to charge them with a lesser offense. That is their choice, which is the main important part. Prosecutors have a lot of discretion and a lot of power. Some other prosecutor duties and powers. Plea bargaining. Prosecutors have the power to decide which cases they want to plea bargain. This is when the prosecutor, defense attorney, defendant, and even sometimes a judge all agree to a negotiated agreement of the punishment. And we'll talk about this more in detail later on. So instead of going to trial, they agree on a specific sentence the defendant will get if he pleads to certain charges. It is the prosecutor that chooses the lesser pleas. About 90% of cases are resolved this way. Most do not go to trial, as we're going to see. Prosecutors also have the power to recommend the amount of bail, even though the final decision is the judge. They can use the amount of bail, though, to pressure the offender into a plea bargain. And then one drawback of being a prosecutor is that they do have to go by the rules of discovery. They have to provide the defense with all evidence, that even the evidence that favors the defendant. The defense, though, does not have to do this for the prosecutor. So the prosecutor has to provide all evidence that the defense can use to assist themselves in trial. It's called rules of discovery. So overall, with the prosecutor, they represent the state. They are very powerful in choosing what charges and what plea bargains. And they have to go by the rules of discovery. Now on the other side, the defense attorney. Offenders did not always have the right to counsel. The Sixth Amendment only gave the right to counsel in federal cases where the defendant could not afford it. It wasn't until 1938 that the right to counsel was extended for poor defendants in federal cases, and in 1963, in the case Gideon v. Wainwright, this is one of those landmark cases, that the right was extended to poor defendants facing felony charges in state courts. And in 1972, the right was extended to misdemeanor cases. So there's been this steady progression of allowing offenders to have the right to counsel when they could not afford it. If there is no possibility of being incarcerated, then the defendant does not have a right to counsel. They do, though, if there is a chance of a suspended sentence, which means a sentence of incarceration kind of hanging over them, but not given to them at that time. The defendant not only has the right to counsel, but the right to effective counsel. Defendants who feel that they have had ineffective counsel are able to appeal their case, but they must be able to prove that their lawyer was incompetent and that his incompetence led to the decision of the case. Defendants also have the right to represent themselves. This is called pro se. If they do that, though, then they can't appeal their case saying they didn't have an effective counsel. So that can work against them. And think about, could you defend someone who you knew was guilty? Defense lawyers get a lot of negative publicity for defending people they know are guilty. But because of the right to counsel that is given to everyone, it is not the job of defense lawyers to only represent people they know are innocent. Everyone is guaranteed a lawyer who can defend their rights. So let's look at the different types of defense attorneys. The first one is a private defense criminal lawyer. They often do not make a good living and have to spend a lot of time finding clients. They sometimes even engage in unethical behavior to find clients and to get paid, such as paying the ambulance drivers, plea bargaining cases that they could win in court because their clients can't pay the trial costs, or letting their clients sit in jail until they can pay the fees. They are often seen as low on the totem pole of lawyers. Then there are court-appointed criminal lawyers. These are the lawyers for defendants who cannot afford one. They can either volunteer to be put on a list that the judge then picks from, or the judge may choose from a list of lawyers who are members of the county bar association. They are often just given an hourly wage. In areas that also use public defenders, court-appointed lawyers are still used for cases where there are multiple offenders, because one lawyer can't represent more than one person in the same case. So often a public defender will take one client and a court-appointed lawyer will take the other client. Then public defenders, these are the lawyers that are paid a fixed salary by the city, county, state, or federal to defend poor defendants. This is what we think of mostly as our court-appointed criminal lawyers, but they are paid a fixed salary, whereas the court-appointed criminal lawyers are paid an hourly wage. Then there are contract lawyers. These are private lawyers or firms that bid for the right to represent poor defendants. So they get a fixed amount of money from the county or state to represent a set number of clients for a set period of time. It's a contract, just like it sounds like. So these are the different kinds of defense attorneys. And one of my internships while in college was actually working for the public defender's office. So I got to sit in court next to actually the public defender in the arraignment court and help them with their paperwork and help them in any way they could and just observe. And it was very interesting to look at how the public defender does their work, and then if we did get a case where there were multiple people in the same case, I did see the judge then call up a court-appointed lawyer, and they would take the other client in the same case. So I've seen this in action, and it's very interesting. So let's go on to the judge. Judges are usually known for wearing the black robes and overseeing trials, but they have a lot of other responsibilities. They determine probable cause, they sign warrants, they inform suspects of their rights, they set and revoke bail, they arraign defendants, and they accept plea bargains. Whatever they are doing, though, their main primary responsibility is to ensure that suspects and defendants are treated fairly and their rights are upheld according to the law. Now, judges are either elected or they are given the position based on a merit system. The merit system was created to try and stop politics from being involved in the elections. In this system, the governor appoints judges from a list of qualified lawyers, and then after a year, the voters vote whether to keep that judge. So the judge has a lot of different duties, besides just sitting up there kind of overseeing trials. It's a very day-to-day, it's very busy. And in the court that I sat in on, it was a very fast-moving court, in, out, in, out. The judge would see probably over 50 people in a day, and they had to stay on top of, okay, were these rights given, and was this client given this type of lawyer? There was a lot of fast-paced motions going on. They set bail in that court that I sat in on. And if they had to, they would take the clients into custody right then. The judge had to order that. So judges are more than just sitting there quietly during a trial. Some courts are very fast-moving and the judges have to be on top of things. So that provides you with a quick overview of the different players in the court system and what their roles are. Now, as we go on to part 2 and I explain the actual court process, now when I say prosecutor, you'll know they are the ones that represent the state. Defense attorney, the one that represents the defendant. And then you'll know the different roles of the judge. So keep those in mind as you go on to part 2.